From 12 News, this is Newsmakers.
Well, this was a big one, wasn't it?
Ground zero for the battle over Trump administration policies has been federal courtrooms across the country, including at U.S. District Court in Providence. But a recent Supreme Court decision has made it harder for judges to intervene on policies they deem unconstitutional. Were judges wielding too much power, or has the High Court undercut a key guardrail to police the executive branch? We'll ask our guest this week on Newsmakers, retired U.S. District Judge Nancy Gertner. Welcome to Newsmakers. I'm Tim White. Ted Nesi is off this week. We are joined by U.S. District Judge Nancy Gertner, retired. Judge Gertner served on the federal bench for 17 years, appointed by President Bill Clinton. She retired in 2011. She's now on the faculty at Harvard Law School. Judge Gertner, it's really good to have you on the program. Thanks for joining us.
It's good to be here.
So, Judge, I want to start broadly before we narrow in on specific cases, specific conversation points. You're not on the bench now, but I imagine that you're still plugged in and talk to those who are. How would you describe the state of things, the morale, if you will, at U.S. district courts?
It is uniquely depressing. It is uniquely troubling now. And why is that? So, judges will issue decisions and could well be reversed. That happens. That doesn't mean very much. This is a different situation in two respects. For one thing, this president has enabled threats against judges that we have never seen before. The things that he has said has delegitimized the enterprise, has delegitimized judges and what they try to do in a way that, frankly, I have never seen before. That has enabled threats that are also like we have never seen before, both in terms of the amount and the nature of the threats. And then you add to that the kinds of comments that he has made and that the Attorney General has made, and even to some degree the Supreme Court has made, that is essentially demeaning the prodigious work of the lower court judges. So it's a perfect storm that leads, when I talk about delegitimizing the court, it's not just, people will not pay attention to the judges. It is that the enterprise is not treated with respect. That triggers disobedience, and that triggers threats. And I don't think I have ever seen it this bad. So
why don't we talk about that U.S. Supreme Court decision? And to do so, we have to do a little bit of basic law school here and talk about preliminary injunctions. Let's have you, the law school professor. How would you define a preliminary injunction? What are they?
Well, in a preliminary injunction, when someone brings a case, it typically takes a while for the case to be resolved on the merits, which means that all the issues actually decided. But there may be instances in which you need emergency relief, where the status quo has to be preserved while the case is being litigated, because you wouldn't want to have a situation where you win at the end of the litigation, but to all intents and purposes, the harm has been done. So from the beginning, we've had the capacity, plaintiffs have had the capacity to move for a preliminary injunction. They have to prove the likelihood of success on the merits, which means a prediction that they are likely to succeed down the road, and that they have irreparable harm unless relief is granted now. There will be irreparable harm unless relief is granted now. Just to give you an example, there were injunctions in numbers of the cases involving mass layoffs in the federal government. The irreparable harm was, if the case takes 6 months to litigate, I cannot be with jobless during that period of 6 months. Something has to be done now. That's my irreparable harm. And what's the likelihood of success on the merits? Well, the argument was the government can't defund an agency. There's irreparable harm in the cases involving USAID. People will die abroad. So this is a classic power of the federal court that makes perfect sense. You don't want to win and lose at the same time. Win at the end but lose because to all intents and purposes, the harm was done.
Well, look, it's safe to say many presidents, not just President Trump, don't love preliminary injunctions because they can become nationwide injunctions. So a judge at U.S. District Court in Boston issues a preliminary injunction in a case against in this case, the Trump administration that did affect things coast to coast. And the recent decision, and you referenced it earlier in the conversation, by Justice Amy Coney Barrett, she wrote the majority opinion, effectively ended that practice by saying, to sum it up probably poorly, whatever a judge decides in Rhode Island, a judge decides in Texas or in Massachusetts, only applies to those jurisdictions. And Judge, for a lot of people, that makes sense. Why should a single U.S. District Court judge be able to halt the policies of a sitting president elected into office beyond the district in which that judge serves? What do you say to that?
Well, if the policy at issue is, in a sense, a nationwide policy, let's not be abstract, take the elimination of birthright citizenship. So the claim here was, if you eliminate birthright citizenship in Massachusetts, that means Rhode Island would have to determine who's a citizen, who has the appropriate papers. When that person crosses a very small, border, there will have to be essentially inconsistent definitions of citizenship across the country. It could affect Medicaid, Medicare. It could affect, enrollment in school. And so, to some degree, the birthright citizenship order eliminating birthright citizenship was the most nationwide one can envision, right? That was the one that had the most implications nationwide. Now, there have always been criticisms of nationwide preliminary injunctions, and there have been, up until now, discussions about how to address it. And one discussion was, for example, have a nationwide injunction, change the law so a nationwide injunction could only be entered in a three-judge court, 3 judges, not just one, or some process for an emergency appeal. So you wouldn't have a district court judge stopping something nationwide and then it taking months and months to finally litigate. So we had procedural discussions about what to do about nationwide injunctions that were going on during the Obama administration and as well as in the Trump administration. It's not the case. So there are 2 things about what the Supreme Court did. First of all the cases in the world to address nationwide injunctions, the birthright citizenship case was perhaps the worst, because that is so clearly about a foundational right and so clearly of nationwide scope that affects every single one of us in every state. So this was the worst case to decide the limitations of nationwide injunctions.
Well, of course, the Supreme Court,
and the court didn't wipe it out. The court essentially said there are 3 exceptions to their prohibition on nationwide injunctions. One is if you have a nationwide class. In other words, you have one person represent everyone in the nation. Within days of the Supreme Court's decision, there was already a class that was certified and established on birthright citizenship, and now, so that's going up. If it's a state, and in the case of the birthright citizenship case, I believe it was 22 states that raised issues that were going to discombobulate all of them. And so with respect to a state, it's conceivable that the only relief that makes sense will be nationwide. And then there's a technical third one, which is the Administrative Procedure Act. Within days of the Barrett decision, judges found class actions, state injunctions, and Administrative Procedure Act, because this was the classic nationwide issue.
And as you point out, we are seeing courts across the country now adjust in the wake of that decision. We're going to take a break here, Judge. When we come back, colleges and universities in the crosshairs of the Trump administration. Stay with us. You're watching Newsmakers. Welcome back to Newsmakers. I'm Tim White. Our guest this week is U.S. District Judge Nancy Gertner, retired. Judge, before we get into the higher education discussion that I really want to have with you. Just a question on to carry over from the first part of the program here. Look, many people think that judges are political creatures. You were appointed by President Clinton, a Democrat. The first Trump administration was very aggressive at filling vacancies on the bench and the federal benches at all levels. What do you say to people who think that judges simply cannot check their biases at the door and make decisions based on their political ideology?
You know, I think that is ridiculous as to apply to what is going on with respect to the Trump administration, right? I think that, biases certainly play a role. Nobody moves to neutral. Nobody can be, perfectly neutral without trying to work to disentangle what their biases are. But pause for a second. The 200 cases that have been brought against the Trump administration, the numbers and numbers of injunctions, no matter who the judge was who appointed, no matter who the president was who appointed the judge, judges have stepped up to the plate, and the issue is not their biases. The issue is that what the Trump administration has been doing is wildly, wildly illegal. And that's why you're seeing judges across, no matter who had selected them, coming up with orders against the Trump administration, and not just ordinary orders, indignant, outrageous. There is no basis for this kind of order. So sure, bias can be an issue, but that is not the issue with respect to the Trump administration now at all.
All right, let's talk about colleges and universities. Again, you teach at Harvard Law School. I should note that Harvard Law School is its own entity. It has its own board and whatnot from Harvard University. But the Trump administration has taken I think it's safe to say, a very aggressive stance with higher education, including Harvard. The Department of Health and Human Services accused Harvard of violating students' civil rights for not doing enough to combat anti-Semitism. You're a Jewish American, and I wonder what your take is on the administration's approach here.
I think that the administration is using anti-Semitism as a ruse. In other words, I don't think it's serious about anti-Semitism. To be sure, after October 7th, there were specific incidents. Harvard investigated those incidents, attempting to redress any problems that came out of that. But what the Trump administration is doing is so far beyond that. What the Trump administration is doing is using the cover of anti-Semitism to try to control Harvard's hiring and firing and the curriculum, effectively to take over a private institution, which is something out of a totalitarian playbook. So to be sure, there were individual incidents, but this was actually something that came up during the hearing the other day before Judge Burroughs. Eliminating funding for cancer research has nothing to do with anti-Semitism. Preventing, changing the nature of the Harvard faculty and interfering in the curriculum has nothing to do with anti-Semitism. So it's clear that anti-Semitism here was a pretext and not real, and intended mainly to gain control of an independent institution, really right out of the playbook of an authoritarian.
Well, no university, maybe Harvard is up there, but Columbia University has felt it more than any other university in this country. And this week, they agreed to pay a $200 million fine to settle a complaint by the Trump administration. Some see that as a capitulation to the administration. Others argue it was necessary to restore that critical research that you just referenced, so that research can continue and the funding can start returning from NIH and so on and so forth. What's your view?
I think it's both is the answer. It's clearly a capitulation because the government had no right to do what it was doing. I can't say this more clearly enough. About 20 years ago, there were concerns about discrimination, sexual harassment on campus, and that triggered investigations of sexual harassment and the way that sexual harassment claims were being addressed. It was not, oh, you have stepped on a line here with respect to sexual harassment, therefore we will defund everything. That's essentially what Trump is trying to do here. If I found you in error with respect to A, I'm going to defund everything. So Columbia, it is a capitulation. There's no question about it. They made a practical decision that in order to save parts of the university, they will give in to this. I hope Harvard doesn't make that decision. I can't say it enough that when the government seeks to control private institutions, we are no longer America. The private institutions that are independent of the government are precisely what distinguishes this country and provides robust basis for democracy. So yes, it's both a capitulation, there's no question about it, because the concerns did not affect those funds on the one hand. On the other hand, I understand why they had to do it.
Well, I want to wrap up the higher ed conversation with this question to you. You said you hope Harvard doesn't do the same thing, but does Columbia's decision to do that make it hard for institutions like Harvard?
It makes it hard for other institutions, but Harvard is really quite unique because of the nature of its, it's a very wealthy institution and wealthier than most. So Columbia will provide an example for other smaller institutions. I don't think it will provide an example for Harvard. Okay. But we have to, again, you have to step back and say, government doesn't have a right to tell private institutions what they should teach or whom they should hire and whom they should admit. You can condition funds on your following the rules. You know, the rules about sexual harassment, the rules about preventing anti-Semitism. But that is a much more narrow enterprise than, by the way, we want to figure out who you're hiring and firing. I mean, the administration just went too far.
Judge, we have about 2 minutes before we have to go to a commercial break. So in that time, I want to ask you about immigration. And as a reporter, I'm seeing anecdotally more criminal complaints or indictments against defendants for illegal re-entry into the country. This isn't new. We used to see some of these, but usually they were associated with other crimes. So there's a narcotics crime, and we're also charging this defendant with illegal re-entry into the country. These are individual cases that I'm seeing come into U.S. District Court in Rhode Island particularly. Does that indicate that the Department of Justice is leaning into these more maybe to get away from immigration courts, or so local police have to honor arrest warrants? What's your take?
I think it's a symbolic political action, right? And what we see in Massachusetts, for example, is someone gets picked up by ICE, and they would then be subject to deportation proceedings. And instead, here, the ICE arrest leads to a criminal complaint in federal court. The magistrate judges are releasing people, and they go back to ICE and they're deported. This is simply a game of numbers. And then the public has to ask whether the resources of the federal government, the criminal resources of the federal government, are being used to get people without any criminal record who simply have illegally entered the country and would be deported. Whether we should use the prodigious resources of the federal government for these purposes, as opposed to drug interdiction, white-collar crime, all the usual ones. This is symbolic and not real. And I think it will have real consequences on the other parts of the federal government, the other work of the federal government.
All right, we're going to take a break here on Newsmakers. When we come back, our conversation with U.S. District Judge Nancy Gertner continues. Stay with us. You're watching Newsmakers. Welcome back to Newsmakers. I'm Tim White. Our guest this week is U.S. District Judge Nancy Gertner, retired. She's now faculty at Harvard Law School. Judge, I want to talk to you about your 17 years on the bench in Boston, federal court in Boston. I've covered the criminal justice system now going on more than 25 years, and I've talked to judges about criminal sentencings, and almost all of them say that sentencing a defendant in a criminal case is one of the hardest things they have to do. Would you, of course, that was before all the turmoil that we've been talking about throughout this program today, but would you agree with that assessment of the job as a federal judge?
There's no question about that. There's no question about it, to basically be responsible, at least technically, for a human being to have their liberty taken away is an extraordinary responsibility. And especially in the past 25 years, when we had the problem of mass incarceration and numbers of people were sentenced to, in my view, sentences which were unfair, unjust, and disproportionate. So I'm actually examining my sentences now, and I'm meeting with some of the men I sentenced to try to find out what I missed, what we all missed, what we should have done. So it is difficult in general. I think it's been particularly difficult in the past 20 or 30 years because sentencing got so incredibly punitive with mandatory minimum sentencing and all of that. And so I think it's just been especially bad now.
We have just under 2 minutes left in the program, Judge, but I'm fascinated by you saying you're meeting with some of the defendants that you had sentenced in the past. Are there any sentences that you wish you could do over again?
All of them, virtually. No, that's an oversight. Virtually all of them. I mean, you understand, I was a judge when there were mandatory minimums and mandatory guidelines, and where all that mattered was, what was your criminal record and how much drugs did you have? And it didn't matter. In the case of one man I write about, that you had a bullet in your brain that you couldn't remove. It didn't matter that you started dealing drugs for school supplies. All sorts of factors that I'm sure the public would understand should mitigate punishment didn't. So I was responsible, because I was the one imposing the sentence, for these extraordinary sentences. There's nothing much I can do to undo that now, except to explain to the public what went wrong and what we should be doing.
30 seconds left here.
A very bizarre retirement.
30 seconds left. Do you think mandatory minimums should go away? Absolutely.
Absolutely. They basically reduce an individual to a category. And the category is, it doesn't matter if you had X number of prior convictions, even if they occurred when you were, a teenager, addicted to drugs or traumatized, we somehow count them. So yes, they should go away.
All right, U.S. District Judge Nancy Gertner, retired. Thank you so much for this conversation. I appreciate it.
You're welcome.
And Ted Nesi will be back next week to join me here on Newsmakers. If you missed any of it, it's on WPRI.com, or you can scan that code for our podcasts. I'm Tim White. We'll see you next week on Newsmakers. Hi, Judge. Are you there?
Very much, Tim. This was interesting.
Yeah, that was a lot of fun. I really appreciate you taking the time. Where are you Zooming from?
I'm in New Hampshire. I'm right by a lake. We move up here, and I work in this shed. So my she shed. So I'm very informal, and no, it's wonderful. So, and when I'm tired, I just jump in the lake. Come on, I'm jumping in the lake. A lot of people think I should jump in the lake.
Yeah, no, that was great. And I'm really happy Judge Smith connected us. So
well, we can talk again. I'm happy to talk to you.
Great. And if your
questions were good questions, so I want to continue to stay in touch.
Yes, I would like that as well. And, if you're ever in our neck of the woods, we'd love to have you on set. But this was great. So thank you again for taking the time.
You're very welcome. Take care.
Bye, Judge. Thanks.